from the appellee so that there'll be no argument by the, no argument by the appellee. So we'll hear from Edward Arnold.
Good afternoon, Your Honors. My name is Edward Ronny Arnold. I am the plaintiff appellant in civil action Edward Ronny Arnold versus Morris Smith Tree Care LLC 22C2167. Civil action Edward Ronny Arnold versus Morris Smith Tree Care is a contract dispute. The merits of this case are the homeowner contracted with the defendant to remove one tree at the homeowner's address. The contract amount was $2,400. This amount was reduced $50 if the homeowner paid cash as opposed to a cashier's check. The defendant removed the tree on the dates of July 12, 2022 and July 13, 2022, to which the homeowner paid the amount of $2,350 in cash. The defendant did not remove all the debris, claiming they would return the following day. This did not occur. On the date of August 4, 2022, the plaintiff was notified by a text message the homeowner owed an additional $5,000 for the tree removal, and this amount was being discounted to $2,500. The defendant refused to remove the remaining debris until the homeowner pays the additional $2,500. The defendant, on the date of August 4th, 2022, claimed the contract converted from a fixed rate of $2,400 to an hourly rate of $500 per hour for a total cost of $7,400, and the homeowner owed an additional $5,000. The specifics of the contract include a mechanic's lien if the homeowner did not pay the charges after completion of the job. The defendant left the homeowner with a claim of an additional $5,000 to remove the one tree, and the defendant did not respond to a notice of intent to file a civil action on the date of August 6, 2022 to remove the remaining tree debris by the date of August 19, 2022. The homeowner contracted with another tree service to remove the remaining debris by the date of August 25, 2022 for the cost of $500 to be paid by cashier's check. On the date of August 24, 2022, the defendant returned to remove the remaining debris. One of the workers attempted to start an argument. The defendant's actions were concerning, as the homeowner believed the defendant was to file a mechanic's lien claiming an additional $5,000. Civil action Edward Ronny Arnold versus Morris Smith Tree Care LLC 22 GC 11739 was filed in General Sessions Court that the homeowner did not owe an additional $5,000. An agreement was reached in General Sessions Court on the date of October 20th, 2022 that the defendant agreed the total cost of the tree removal was $2,400, reduced by $50, and the contract was paid in full. The defendant would pay court costs and send a statement to the plaintiff the contract was paid in full. This did not occur, as the order submitted to the court by the court clerk and filed on the date of October 21st, 2022 stated the civil action was dismissed with prejudice and the plaintiff would pay all costs, to which both parties agreed that defendant will mark in full as to services rendered by the defendant. This was not accurate as to the agreement between the plaintiff and the defendant. Civil action Edward Ronny Arnold versus Morris Smith Tree Care LLC 2GC 11739 was appealed on the date of October 25th, 2022 and assigned civil action 22C2167 to the 8th Circuit Court, Judge Lynn Ingram. On the day of December 29, 2022, the plaintiff filed a motion for default judgment as the defendant violated Rule 12.01 in not responding to the civil action appealed on the date of October 25th, 2022. On the date of January 20th, 2023, the trial court denied the plaintiff's motion for a default judgment, ruling the defendant's response to an email for a date to set the trial was a response to the complaint. The court stated the case was in the discovery phase, and Judge Ingram moved the non-jury trial date from February the 7th, 2023 to the date of April 3rd, 2023, an estimated 3 days. The defendant filed a motion to dismiss on the date of January 25th, 2023, to be heard on the date of February the 3rd, 2023. The trial court granted the motion, although it violated the 14-day rule notice of motion hearing. The plaintiff filed their response to the defendant's motion to dismiss on the date of January 27, 2023, in compliance with the 5-day rule for response to the Friday, February 3rd, 2023 motion to dismiss. As stated in court on the date of February 3rd, 2023, and as shown in the email chain between the plaintiff appellant, defendant appealee, and the trial court, the defendant appealee stated and wrote they intended to file the contested amount as a loss on the 2022 federal business income tax form. The issue before the court is the contract signed on the date of April 28, 2022, states specifically the total cost to remove the one tree and remove the debris is $2,400. The contract does not state the cost to remove the one tree is based on an hourly fee of $500 per hour, and the contract does not state the removal of a fence is a requirement for the cost of $2,400. The defendant appealee presented no evidence the plaintiff appellant owed an additional $5,000 to remove the tree. The plaintiff appellant presented evidence through a text message chain, email chain, notarized photographs, and sworn affidavits. The plaintiff appellant did not owe an additional $5,000. Trial court was tasked with litigating the contract as a fixed rate contract to which the plaintiff appellant fulfilled their obligation in paying $2,350 on the date of July 13th, 2022, to which the contract's mechanics lien does not apply, as the plaintiff appellant paid the contracted amount. The trial court did not litigate the contract dispute, and the trial court erred in conducting court business through unsecured emails between the trial court, plaintiff, and defendant. The trial court excluded emails in the technical record to where the trial court issued orders but did not produce orders. The trial court ruled the defendant appealee, by the response of an email for a court date, met the requirements of Rule 12.01 to respond to a complaint within a period of 30 days. The trial court did not include the email response in the technical record as evidence of the trial court's reasoning for denying the plaintiff appellant's motion for a default judgment on the date of January 20th, 2023. The trial court excluded emails in the technical record to where the defendant appealee wrote they intended to file the disputed amount as a loss on their 2022 federal business income tax. The trial court in an email chain stated it's true.
Let me ask you, what relief are you asking this court to grant you?
The only relief that I've asked is that I don't owe the money, period. I fulfill.
That you owe money?
Pardon?
Did the trial court find that you didn't owe any additional money?
Well, this is the issue with the trial court. I was simply asked, do I owe money? I said no. They asked the defendant, does he owe money? No. But then they added, because we're going to file it as a loss on our 2022 federal income tax.
Why does that matter to you, what they do?
Well, first of all, it's fraud. I don't owe the money. You can't file a loss unless the court has adjudicated that the money's owed and the court has adjudicated that you can't pay. I've got a car right now that in another case before this court,
my
but I
question
can't file it as a loss.
I mean, why do you care what they do on tax return?
Because
And
it's,
how does it impact you at all?
because it says I didn't pay the bill. It says I owed the money. I don't owe the money.
You know, when you prepare your tax return, and if you're showing a loss, you don't have a name of your clients on your tax return.
I don't care. I don't owe the people the money.
Have they sued you for any additional?
No, they have not. Because I filed a civil action that I don't owe the $5,000. What they did is they came back, if you'll read the brief, they said I owed $5,000, but they reduced it to $2,500.
Yeah, but I'm trying to figure out why you even filed an appeal where the trial court found that you didn't owe them any additional money. Why are you appealing that determination?
Because what the court basically ruled was I owed the money.
Where does a court say that in its order?
It doesn't say that. What I'm saying is that what we had in there is the issue is we got a mechanic's lien. Mechanic's lien says if you don't pay this amount of money, we can come and we can file something at your house. What was presented to the court, which was not included in there, is I located what's called social media posts that indicated, that said that in the past this company had told people they owed additional money and they threatened to do a mechanic's lien against their house. So the issue is that...
Have they filed a lien against your house?
No, they have not, but they would have filed if I had not appealed it. Because the first court, we had an agreement, a very simple agreement. The total amount was $2,400 minus $50. I paid it. It's all over and done. That was not what was given to the court. The court was given that they had fulfilled their requirement. According to the contract and mechanic's lien, is that what you have is that they can file against your home if you have not paid the amount in full. What had happened was, in this case, is that they refused to pick up the remaining tree debris until I paid them $2,500. What had happened in the brief is that the day before they contacted me and said I owed them money, we were visited by Metro Codes. Someone had filed an anonymous complaint that we had tree debris in our front yard. The guy came out, looked at it, gave us until the date of August the 25th to remove the debris or would be filed daily. I went and I found a company that was going to remove it for $500, to which I was going to file a civil action against them for the $500. And what you have is that you can only sue for what's called the cost of correcting the work itself, which at this point, as of August the 24th, I was going to pay $500 by cashier's check to remove the debris to keep from being fined by Metro Codes because it's there, to which they refused to pick it up unless I paid them $2,500. What happened was they arrived before the other people arrived, and they removed it. But because the person made a lot of statements when they picked it up, that I felt that they were going to try to do a mechanic's lien. So the issue was that what happened with the court is the court had full knowledge that the court, my wife and I gave sworn affidavits. The two people that showed, basically what they did, they impeached themselves because they made statements. They were claiming on a certain date there was a big argument, which it did not happen. The trial court took their statements over sworn affidavits, to which those sworn affidavits were not initially put in there. I think my time's up. We have, what we have here is we had also an issue of what's called ex parte communications. I was contacted by a lady who said she was their attorney, stated that she had contacted the court, and the court wanted to advise them to offer me a deal where they will reimburse me for my expenses if I agree to allow them to file the amount on their 2024 income tax. That is a violation of 26 U.S.C. 7206. It's called fraud and false statements. They were going to put in their income tax that I owe them the money. I don't owe them the money. Thank you.
Thank you, Mr. Arnold. We will take this matter under advisement and render an opinion as soon as possible.